Alright, so what we're going to look at in this lesson is moving into the Supreme Court and kind of talking about some of those things. What we're going to do is establish some of the types of courts that exist within the United States and kind of how those things work. Alright, so the first thing we're going to look at here are district courts. Federal district courts are trial courts. So a trial court is you're going to have a prosecutor and you're going to have a defendant, and they're going to argue their cases in front of these. Alright, states are divided into 94 different districts, each having a federal district court. So when you commit the crime, if you do commit a crime and you're going to be put on trial for that crime, and it's a federal crime, then it's going to be heard in whatever federal district in which you are zoned for. Alright, district courts have jurisdiction to hear cases involving federal questions. So some of those things are going to look at federal statutory law or constitutional law and cases involving citizens of different states. Alright, very few cases are appealed from this court. So most of the time, when a federal district court makes a decision, that's the decision that's really going to stand in that situation. Alright, and remember, federal statutory law, so statutes that we talked about previously, statutes are laws that are written down. So these are things that the federal government, that the Congress has actually written down and passed. Constitutional law obviously has to do with the Constitution of the United States, and then issues of different people of different states. So say I'm in Florida and I want to sue somebody from Georgia, then that's more than likely going to end up in a federal district court. All right, district courts try both criminal and civil federal cases. All right, criminal generally has to do with some sort of jail time or something like that, and a civil federal case generally has to do with some sort of monetary damage. And then they use two different types of juries, both the grand jury and the petit jury, and we're going to look at those in a little bit more detail here. Petit juries are trial juries. They usually consist of 6 to 12 people, and they weigh the evidence presented in a trial, and they render a verdict of guilty or not guilty. All right, so they're going to hear the evidence, they're going to hear the prosecution make their case, they're going to hear the defense make their case, they're going to deliberate about all of the evidence and all of the testimony and things like that, and then they're going to determine whether or not you're guilty or not guilty. Now notice with that, it's guilty or not guilty. You don't presume somebody as to be innocent. You presume them as being not guilty because there was not enough evidence to be able to prosecute them. But you don't necessarily say that they're innocent because you can't necessarily exonerate them from all possibility that they may have committed the crime. Alright, grand juries decide whether a case should go to trial based upon the prosecution's evidence. So the prosecution is going to gather all of the evidence, they're going to make a case for why there's enough evidence to try and seek a conviction for that individual, and then the grand jury is going to determine if there is enough evidence or not. If there is enough evidence, then the person will be indicted for the crime, which means that they will actually be formally charged for it, or if there's not enough evidence for an indictment, then the charges will be dismissed. Alright. In order for a case to be heard in our legal system, the plaintiff must have standing to sue. This means that the plaintiff generally must have sustained or are in immediate danger of sustaining a direct and substantial injury from another person or an action of government. So it's not where you can just kind of off the wall sue for whatever you want to sue for. You have to have sustained an injury, or you have to be able to show that you're going to sustain an injury from that. And we don't necessarily mean injury like, physical injury. It could have to do with income. It could have to do with anything like that. So if I'm being discriminated upon based upon race or based upon gender or something like that for not getting that job, even though I haven't necessarily sustained something illegal happening to me, there's that potential injury of not gaining income from that. So that's why that discriminatory process could be give you standing to sue. All right, so there's some different types of lawsuits that we can look at here. You've got class action lawsuits. A class action lawsuit is a lawsuit that takes place when you have a large group of people that are all part of the lawsuit but aren't necessarily directly involved in it. So it would be something like, say there were faulty seat belts in a car, and they didn't do enough to fix those. So you could have everybody who was affected by those faulty seatbelts, or everybody who owns one of those cars that has a faulty seatbelt, and their lawsuit could be brought forth on behalf of everybody who owns that. Now, the thing that ends up happening with class action lawsuits is that those settlements have to be distributed amongst everybody who's part of that lawsuit. So you get very little any sort of monetary gain out of it. However, the idea behind it is to try and bring about change so that those issues don't exist in the future. All right. Conflicts must also be justiciable disputes. This means that they have to be capable of being settled by legal methods. So if there isn't law that has to do with it, if they're not precedents, if there's really nothing kind of the legal system can do about it, then there's not much you can do to sue with that concept. All right. So look at some of the different courts that exist. The Court of International Trade, which is a constitutional court, was formerly known as the United States Customs Court. The Court of International Trade has jurisdiction over cases dealing with tariffs, and remember, a tariff is a tax on an import. Citizens who believe that tariffs are too high bring most of the cases heard in this court. And the court is based out of New York, even though it is a federal court. You got to think about that. That's more than likely because of the amount of trade that comes in and out of New York. That's a good place to hold that, so you're kind of in the center of everything that's going on. All right. We also have the U.S. Claims Court, which handles cases levied against the United States for money damages. So say I'm a company and I provide paper to the U.S. government, and the U.S. government doesn't pay me for the paper that I give them. If I sue them to try and recover that money that they should have paid me for the goods that I provided, then it's going to go to the U.S. Claims Court. All right. The U.S. Tax Court hears cases having to do with taxes. It hears cases relating to federal taxes. Here's cases where people disagree with the IRS or other Treasury Department agency rulings about federal taxes, and it handles cases appealed from lower level tax courts. We also have the Court of Military Appeals. This is the Armed Forces Highest Appeals Court. These are cases involving those convicted of breaking military law. The Court of Military Appeals is referred to as the GI Supreme Court, and the GI Supreme Court has the power to review these decisions. All right, so you look at this, this is really as far as you're going to get to go if you commit a crime while you're in the military. You have the courts of Washington, D.C., which handle both civil and criminal cases in Washington, D.C., and you've got the Court of Veterans Appeals, which has to do with unsettled claims involving veterans. So when we look at these courts, there are two different types of jurisdiction that we can look at. You can have original jurisdiction, and you can have appellate jurisdiction. If you have original jurisdiction, it means that you are the first court to hear anything regarding that case. So, as it says here, original jurisdiction involves cases heard by the court for the first time in a particular geographic area or sphere of the law. So it has to be the first time that it's being heard in order for it to be considered original jurisdiction. So those 94 district courts, that is going to be original jurisdiction. All right. Most state courts, unless you get to what we're going to talk about here in a second, the appellate level, the first time it's heard in a state court, that is original jurisdiction. Now, appellate jurisdiction applies when courts have the right to review cases from lower courts on appeal. So if it's appellate jurisdiction, it means you are hearing it after the first time it's been heard. The final appeal that you can get in the United States is at the Supreme Court level. Appellate courts never have original jurisdiction. The one exception to this is the Supreme Court, and the Supreme Court does have some times in which it would be considered to have original jurisdiction. But the vast majority of the cases that they get are from their appellate jurisdiction. All right. Federal jurisdiction covers certain types of cases. So if it's a federal case, it's going to involve U.S. law. So federal law that's passed by the National Congress. It's going to have to deal with treaties with foreign nations. So if there's some dispute over how a treaty should be enforced or something like that, a state's not going to try that case. The federal courts are going to try that case. Interpretations of the Constitution, that's going to be a federal issue. Bankruptcy and cases involving admiralty or maritime law. All of those things are federal concepts. So any sort of bankruptcy law or anything like that is going to come from the federal level. Federal law hears cases that involve ambassadors and other representatives of foreign government. So if you're going to sue an ambassador or you're going to sue somebody from another government, that's going to be heard in the federal court. The U.S. government or one of its offices or agencies, so if you sue our government or if you sue like one of the departments, like you wanted to sue the Department of Transportation or the EPA or something like that, then that's going to be heard at the district level. Citizens of different states, like we said earlier, that if I'm from Florida and I want to sue somebody from Georgia, that's going to be heard at the district level. A state and a citizen of a different state. So like say I go to Georgia and I feel Georgia hasn't protected my rights and I want to sue the state of Georgia, then that would be heard at the district court level. Citizens of the same state claiming lands under grants of different states, and then a state or its citizens and a foreign country or its citizens. Those are all going to be heard at the district level. State courts have jurisdiction over cases involving state laws. Okay, and that's pretty much all you need to do with state courts, is that know that if it's a state crime that you've broken, then it's going to be heard at the state court level. All right, concurrent jurisdiction occurs in cases involving a person of different states in disputes of at least $50,000. So if you've got concurrent jurisdiction, it means that it can be both heard at the state level and at the federal level. All right, if you are tried for the same crime at both the state and federal level, it's not considered to be a violation of the double jeopardy clause of the Fifth Amendment, but it is considered to be dual sovereignty, that because each of those courts are independent, that they have the right to be able to do that. All right, the appellate court is an appeal court, and like we said just a second ago, they only have appellate jurisdiction while the original court that hears it has original jurisdiction. All right, so we look at constitutional courts that include the federal district courts, which we've talked about, the Federal Court of Appeals, which we've talked about, the United States Court of International Trade, which was one of the first things that we talked about, and these courts are all established under the provisions of Article 3 of the Constitution. All right, one of the last things that we're going to talk about here is this idea of senatorial courtesy. So, as we talked about in the executive unit, it is the president that appoints judges to the judiciary, and they do that at all of those federal levels. So whether it be a district court, whether it be appellate court, whether it be the Supreme Court, the president is the one who is appointing all of these individuals to these positions. All right, because the other court levels, anything not at the Supreme Court level, because they are much lower profile court positions, what the president is going to do is they're going to participate in something known as senatorial courtesy, and what that means is that they are going to tell the senators in the Judiciary Committee who they are planning on appointing to those judgeships, so that they have appropriate time to do research, so that they know whether or not they want to confirm those people or not.